Welcome to the channel and thank you for choosing to watch this video. My name is Jonathan and I work in the offshore global business industry. In the previous video, we covered company constitutions by going over their definition, purpose, and related provisions applicable to companies law, specifically regarding the Mauritius Companies Act 2001. In this video entitled, What is a Shareholders Agreement? How to draft Shareholders Agreement? We shall be covering such agreement which, just as constitutions, serve as an important internal corporate document regulating the rules of engagement amongst private company shareholders. First, we will go over the general background of shareholders agreements. Second, we will elaborate in detail on what shareholders agreements are. Third, we will cover some of the key advantages of adopting shareholders agreements. And finally, we will be covering Section 272 of the Mauritius Companies Act 2001 concerning legislative provisions applicable to shareholders agreements. I hope you enjoyed this video, and as usual, I wish you a reflective and insightful viewing. As discussed in the previous video, a company in Mauritius has the option, but not the obligation, to adopt a constitution upon incorporation, although this requirement may vary depending on the company laws of different jurisdictions. Company constitutions establish a fundamental framework of rules governing the company. Many small companies typically opt for model constitutions derived from the current Companies Act at the time of their establishment, this under the second schedule of the Act itself. These standard constitutions offer basic provisions suitable for companies with a clear distinction between ownership and management. However, they often lack sufficient coverage for addressing various issues that may arise, particularly in small companies where majority shareholders also serve as directors or in joint ventures. In such cases, companies with multiple shareholders should consider drafting a shareholders agreement, which, alongside a constitution, must be vetted and approved by a legal and lawful professional, because if adopted, the shareholders agreement will be referred to in a company's constitution. Although not legally mandated under the Companies Act in Mauritius, such shareholders agreements can immensely be beneficial in resolving disputes or unexpected events, safeguarding shareholders' investments, and fostering equitable relationships among shareholders. Before moving on to the next section of this video, let's take a minute to reflect, review, and discuss some common issues encountered in practice concerning companies, their shareholders, and directors. These include situations where one or more parties are excluded from participating in the management of the business. Shareholders disagree on critical matters such as selling the business, approving major transactions, or changing the business direction. Shareholder or shareholders perceive that the company is being operated to benefit certain members to the detriment of others. There is a breakdown in the relationship between shareholders, leading to a deadlock that prevents the company from functioning. And finally, the parties involved wish to part ways but cannot reach an agreement on the terms. If you are enjoying the content of this video so far, I'd really appreciate it if you could post a like on the video and perhaps even subscribe to the channel, as this would help my growth with the YouTube algorithm and analytics to reach a wider audience. Lastly, if you would be interested in being a sponsor of the next video for 30 to 60 seconds, feel free to email me at theglobalbusinesschannel@gmail.com to discuss further. Now, back to the video. A shareholders agreement is a straightforward contract or agreement made by some or all shareholders within a company to regulate their relationship. Typically, it involves the agreement and consent of all shareholders, though sometimes it may only involve shareholders of a specific class, most often those shareholders who hold voting rights in a company. It works alongside the Constitution but can address a range of issues not typically covered in the Constitution. Provisions found in shareholders agreement are typically more detailed and provide very specific and elaborate provisions, terms, and conditions that would not be listed in a company constitution. This agreement establishes a contractual relationship among the parties and imposes a legal obligation on all parties to adhere to its terms. Shareholders' agreements offer great flexibility in their content and cannot be altered without the consent of all parties involved. This sets them apart from constitutions, which can usually be changed by a special resolution requiring 75% of eligible shareholders entitled to vote. Shareholders' agreements are particularly valuable in safeguarding minority shareholder rights since they bind all shareholders and require unanimous agreement for any changes. Unlike company law, which typically doesn't allow a company to bind itself, shareholders' agreements can enforce certain actions or restrictions. They can also prevent the removal of a director without the agreement of all shareholders. Moreover, the contents of a shareholders' agreement can be kept confidential, unlike a company's constitution, which is, in Mauritius, publicly available upon request. These agreements can address deadlock situations, and any breach allows affected shareholders to seek damages through a simple contract, avoiding the complexities and expenses associated with company law protections for minorities. It is important to note that clients may hesitate to invest in drafting a shareholders' agreement, but professional advisors or even management companies should emphasize its benefits. At the start of a new business venture, clients and investors might overlook potential conflicts or decision-making challenges due to excitement. Skilled advisors play a crucial role in reminding clients about the potential risks and ensuring thorough planning. Having a well-drafted shareholders' agreement signals maturity and professionalism to lenders and investors, suggesting stability in the business and boosting credibility for the founders who have made such agreements. So what are some of the key advantages of adopting shareholders' agreements? These can be broken down into addressing and providing resolution mechanisms for the following generally encountered categories, which are dispute resolutions, key decision-making within the company, the protection of minority shareholders, meaning those holding less than 50% of the outstanding shares, the protection of majority shareholders, controlling the transfer of shares, linking shareholding to employment, regulating shareholders and directors, and dividend and distribution policies. Disagreements are common in small owner-managed companies, often involving family members, close friends, or long-term business partners. These disputes may concern various issues like workload distribution, salaries, dividends, admitting new shareholders, selecting directors, or the business's direction. A shareholders' agreement can address such disputes by outlining processes for mediation or arbitration and providing exit mechanisms if agreements cannot be reached. This is crucial, especially in 50-50 companies where deadlock situations can arise, jeopardizing the business's future. The shareholders' agreement can include provisions for one party to buy out the other or for the prompt sale of the business. Different clauses may be used for these mechanisms, but they must be carefully crafted to suit the company's specific circumstances. The standard constitution and company law primarily give power to directors for most management decisions, leaving only a few key powers to shareholders, like changing the constitution or removing a director, for example. This means minority shareholders often have little influence, especially in small companies, where power is concentrated among a few majority shareholders. Since constitutions can be changed easily, it is crucial to protect minority shareholders through binding agreements. Shareholders' agreements typically require all shareholders to agree on important decisions regardless of their share size. These agreements commonly cover decisions such as issuing new shares, appointing or removing directors, transferring assets, setting directors' compensation, borrowing, changing business scope, entering significant contracts, or legal actions. While these provisions shouldn't excessively restrict directors, they aim to prevent unfair actions or decisions that harm the business's value. Furthermore, it is customary to include a tag-along clause in the agreement. These clauses become effective when the business is sold, allowing minority shareholders to sell their shares to the buyer at the same price as the majority shareholders. This measure ensures that the majority shareholders cannot sell their shares to a buyer without offering the same opportunity to the minority shareholders, thereby preventing the latter from being left behind with a new owner. The inclusion of the drag-along clause aims to prevent the minority shareholders in return from obstructing the sale of a business by refusing to sell their stake. This clause stipulates that once a specific level of agreement is attained, the minority shareholders are obligated to sell their shares to the buyer, granted they are offered the same terms as the majority shareholders. One crucial aspect to address is what happens when a shareholder wishes to leave the company. Without a specific clause in a shareholders agreement, the departing shareholder may struggle to sell their shares if directors refuse to approve the transfer, which can be challenging and costly to contest. This absence of a market for the shares typically forces the minority shareholder to sell at the discounted rate to existing shareholders, or face the possibility of the majority shareholder selling shares to an outsider without their approval, potentially disrupting the company's operations. Therefore, it is vital to establish a clear procedure for selling shares. Generally, shareholders' agreements stipulate that shares must be offered to remaining shareholders first. This is referred to as a preemptive provision, with the outgoing shareholder valuing the shares or an independent expert determining their worth if a mutual agreement on price isn't reached. Decisions regarding whether remaining shareholders are obligated to purchase the shares and how the purchase would be funded need to be made. Additionally, provisions may include offering shares to the company or selling to a third party, albeit with potential challenges. Such clauses preemptively address issues before they arise, especially in cases where shareholders have close personal ties. Many shareholders incorrectly assume that standard company law prevents shares from being transferred outside the existing shareholder cycle, but this isn't always the case. Furthermore, the agreement may outline procedures for situations such as a shareholder's death, often incorporating cross-option provisions where surviving shareholders and personal representatives are granted options for buying or selling shares. Additionally, shareholders may secure term assurance life policies to ensure the value of their shares benefits their family without complications for other shareholders. In many cases, directors or key employees also hold shares in a company. If they leave the business, provisions must ensure they sell their shares back to the company or other shareholders. These provisions outline the process, often including good and bad leaver clauses for valuation. Good leavers leaving amicably receive fair valuations based on normal principles. Conversely, bad leavers dismissed for misconduct or resigning due to disputes may receive only a nominal sum for their shares. The shareholders' agreement can establish a clear framework for how dividends will be handled within the company. This policy ensures that shareholders are in agreement on dividend distribution. For instance, the shareholders' agreement may specify a minimum percentage of profits to be allocated as dividends, ensuring that shareholders receive a fair return on their investment. This percentage can vary based on the company's financial performance and profitability. Shareholders may hold different classes of shares, each entitled to varying dividend amounts. The agreement can outline these distinctions, ensuring transparency and fairness in dividend distribution, based on the rights associated with each class of shares. There may be instances where the company decides not to distribute dividends due to financial constraints or strategic reasons. The shareholders' agreement can detail such situations and provide guidelines on how this decision will be made, ensuring clarity and predictability for shareholders. Overall, the dividend policy outlined in a shareholders agreement serves to promote transparency, fairness, and consistency in dividend distribution, ultimately contributing to the stability and trust within the company. There are no specific restrictions on the topics that can be addressed in a shareholders agreement. It can encompass various aspects such as financing arrangements for the company. This may involve shareholders committing to provide additional funding if needed, outlining the nature and terms of such funding. Additionally, clauses can address board composition, director voting procedures, and the parties' goals for the company's future direction. We are now going to go over the main provisions of the Mauritius Companies Act 2001 regarding shareholders agreements, and you should refer to your company's law wherever you might be or regarding any concerned jurisdictions for your companies. I will not be reading word for word what is therein, but rather will simplify it in an understandable format. Please do pause the video and read each subsection beforehand so what I say makes sense to you once I tackle each section. Section 272(1) states that if every shareholder in a private company agrees on a decision or action, it is considered authorized by the company, superseding a company's constitution, so long as it does not contravene the Act. Also, certain rules mentioned in the 11th schedule of the Act do not apply to that action. These are now being shown on screen. Moving on to Section 272(2), with regard to Section 272(1) states that all shareholders of a private company can agree on certain actions like issuing shares, making distributions, buying back shares, giving financial help for share purchases, paying directors, making contracts with interested directors, entering into major transactions, or ratifying actions after the fact. If they all agree, these actions are valid for the company, even if they go against the Constitution. Section 272(3) states that if a company makes a distribution to a shareholder and then fails to pass the solvency test under Section 6 of the Act, that distribution is considered invalid. Section 272(4) implies that if a distribution made to a shareholder is considered invalid, the company can ask the shareholder to give it back, except if A. the shareholder got the distribution in good faith and didn't know about the company's solvency issue, B. the shareholder has acted based on the distribution's validity, or C. it would be unfair to ask for repayment. Section 272(5) stipulates that if there weren't good reasons to believe the company could meet the solvency test under Section 6 of the Act, after making an invalid distribution, each shareholder who agreed to it is responsible for repaying the company any part of the distribution that can't be recovered from the other shareholders who got it. Section 272(6) states that if the Mauritian courts finds in a case against a shareholder that the company could have met the solvency test by giving a smaller distribution, it can either let the shareholder keep that amount or excuse them from being responsible for it. Section 272(7) implies that despite other provisions of the Act, all shareholders or members of a private company can, with a written agreement, limit the directors' freedom and abilities to run the company's business. They can also give certain powers and decisions to anyone involved in the agreement, whether they're a shareholder, member, or director of the company. Regarding Section 272(8), someone who is part of a unanimous shareholder agreement under Section 272(7) and gets given powers and decisions through it will have the same rights, powers, and responsibilities as a director of the company, as long as the agreement says so. The directors involved will be released from their responsibilities to that extent, as long as it's allowed by Section 131(2) of the Act. Section 272(9) stipulates that if someone who owns all the shares in a private company writes a declaration limiting a director's powers to manage the company, that declaration is treated as a unanimous shareholder agreement. Section 272(10) in turn states that unanimous shareholder agreement under Section 272(7) won't take effect until all directors of the company, and for companies with a global business license, its management company, and for an authorized company, its registered agent, have been informed about its contents. Also, notice of the agreement and its impact must be provided to the Registrar of Companies. And finally, Section 272(10) states that subject to subsection 7 and 10, don't exempt directors of the company from their duty to submit any necessary returns or notices to the registrar as mandated by this Act. Before closing off this video, I just want you to know that in the next one, we shall be covering companies issued versus outstanding shares, each having a varying concept, although they do tend to be interchangeably used. Once again, thank you so much for watching this video until the end. This is hugely appreciated by me, and I hope it provided you with valuable information, insights, and key takeaways. If you enjoyed the content of this video, it would mean a lot if you would click on the like button to help with the YouTube algorithm if you haven't already done so. As always, I will be posting frequent and insightful content, so feel free to come back to the channel for more videos concerning the offshore, global, and financial services industries. Stay safe and healthy, guys. I'll see you in the next one. Cheerios.